Hi, everyone, and welcome to another episode of Sterling Live. My name is Caitlin Brower. I am Sterling's social media manager. We have a great episode for you today, and I'm so excited that one of our, most seasoned guests is back. Angela Preston is here. I think she's been on Sterling Live like 5 times now. So I am so thrilled that Angela is back with us today. So Angela is our vice president and, senior vice president and counsel of corporate ethics and compliance. And I'm super excited for Angela to be here because today we are doing an FCRA update recap. So last week we did host an FCRA update webinar, and today we are recapping all the goodness for you. So Angela, thank you so much for joining us today on Sterling Live. Can you go ahead and introduce yourself to the audience?
Sure. Hi, Caitlin. Thanks for having me back. I didn't know I was like one of your most seasoned guests, but I'll take that as a compliment that you keep asking me back.
Absolutely.
So, as you mentioned, I'm with Sterling. I'm our Senior Vice President and Counsel for Corporate Ethics and Compliance. That's a long way of saying that I lead our compliance organization. I've been with Sterling for going on 6 years now. And prior to Sterling, I've been active in the industry. I've had about a 20-year career in compliance and background screening compliance. So I've dedicated most of my legal career in dealing with all of the fun legal and compliance issues related to background checks. And throughout my career, I've also had an opportunity to lead the industry as a volunteer. I've chaired our global trade association, the Professional Background Screeners Association, the PBSA. And prior to serving as chair, I served on the board for many years. Through that experience and through my continued volunteer efforts there, it's given me a lot of insight into all of what goes into background screening compliance, all of the regulatory oversight. I've had an opportunity to really represent the association in Washington and lobby on behalf of the industry, and really work with a lot of our employer clients on understanding the issues that are important to clients and working to make the laws manageable and keep doing what we do.
Yeah, that's great. So not only a seasoned guest on Sterling Live, also a seasoned Sterling employee and professional in this space. So I always learn so much from all the content that Angela produces and gives our audience. So everyone who is tuning in live today, right now, or watching this episode on demand, you are going to learn so much. So definitely get that pen and paper out because you're going to want to jot down a lot of notes. So before we get started into the conversation, I do want to remind our audience who's here live with us now across Facebook, LinkedIn, and YouTube. If you have questions for Angela at all during the show, go ahead in the comment section across these platforms and submit your questions, and I will take them and I will field them over to Angela as I see fit. So let's go ahead and get started. So I do want to do a quick overview of the actual FCRA update that we did host last week. So just kind of an overview. So how did the live event go, Angela?
It was great. We had a great audience. It was moderated by Angela Stell, who is our head of marketing, our chief marketing officer at Sterling. And Angela fielded the questions, and the format was really answering all of your compliance questions answered. It was kind of like stump the compliance person. So we had solicited some questions in advance, and we got quite a few of those, and then we took questions live as well. And it was really focused on, these are the issues that are of top of mind for our clients. This is the stuff that's keeping you up at night. And there's so much going on legislatively at the state and local level, and there's so much going on with litigation, and how do you keep up with it all? So this was really a little bit, and it all related back to, it all sort of overlaps and intertwines with Fair Credit Reporting Act. So when we talk about some of these state and local legislative issues, they're not necessarily Fair Credit Reporting Act, but they impact and they address similar issues. So we kind of bundle all of that stuff together and we call it FCRA update, but it really is much more than that. So I encourage you to tune into the replay of the webinar if you're curious about that.
So why is it so critical for an organization like Sterling to put on events like this for not only our clients, but prospects and just like the general public?
Yeah, I mean, it's just a very rapidly changing environment. Things are changing weekly. I mean, there's new stuff that pops up overnight. And let's face it, I mean, everybody out there has a job to do, and maybe your primary job isn't to track compliance issues, and maybe you're not, it's not your role within your organization. So we do it. That's what I do. That's what my team does. So we want to make sure that we're sharing that information routinely so that everybody stays.
Great. I'm very happy to be a part of an organization that does always put this information out there. And we truly are out there to help, to guide organizations, make the right decisions. So I think that's great. We did run 2 polls during the webinar. One of my favorite things that we always do, because we're gathering insights from the audience in real time. So we asked 2 questions. We asked, what is the background compliance issue that keeps you up at night? And then we also asked, what is your go-to resource for background screening compliance updates? So for the first question, we had the options of class action litigation for non-compliance, EEOC or other regulatory investigations or audits, FCRA compliance, and then state and local issues. So a majority of the crew, about 23%, went with state and local issues. So just want to gather, your initial thoughts on that.
Yeah, that's not really surprising. I mean, most of the action these days is at the state and local level. And, when DC is in gridlock, as it has been for several years, based on just a lot of, the elections and a lot of focus elsewhere, there hasn't been a lot happening at the federal level. So when people don't get action at the federal level, they take it local, they take it to the states and their local governments, and that's where the action is. So, and with, 50 states and territories and all of the cities and municipalities and over 3,000 local jurisdictions, that's where the change happens most frequently.
So for the second poll question for the go-to resources for background screening compliance, the options were Google or web alerts, internal resource, so an internal team or in-house compliance legal, my background screening provider, or outside paid legal compliance resource. So majority here, around 26%, was an outside or paid legal compliance resource. So initial thoughts there.
Yeah, I mean, that just tells you that, folks are having to look elsewhere for this information. A lot of organizations don't have their own inside department to deal with this stuff. So that's why it's so important. I will say that on the last question, to be fair, we did give the option to select all of the above, which was, that was, I guess, my lack of marketing experience to know that you shouldn't ask that question because to be fair, people selected that all of the above, all of those issues were keeping them up at night, and so not to underestimate the fact that all of those factors are important. But yeah, I think people are looking for more information. Before we dive into some of that, I did want to just take a second to give my legal disclaimer that even though I am a lawyer and I'm a lawyer for Sterling, I'm not here to give legal advice, and we don't provide legal advice. We're not a law firm. So I just want to throw out that little disclaimer before we really get into some of the issues.
Yeah, and definitely important for sure. We don't need anything bad to happen. So great to throw that out there. So Angela, you did touch on, kind of the format of the FCRA update last week. So, it was a Q&A. We definitely, no one stumped you, I don't think. So we're not going to try to stump you today. So we're going to go over the most popular questions that came out of the update. We do want to recap on those. There was a couple of questions we couldn't get to because there was a lot coming in. So we'll address address some of those. And yeah, that's basically just kind of, the format of today's episode, really giving the people what they want with all of this question. And then wrapping up today, which is kind of how people can continue to stay up to date and remain compliant. We will guide you on the best way to do that. So to start, I want to talk about criminal background check best practices. So one of the most popular questions that came out of the FCRA update that we had, and it's a very popular topic right now. So can you explain fair chance or second chance hiring laws?
Sure. So fair chance or so-called second chance hiring laws are enacted to provide opportunities to people who have been previously convicted of crimes.
Mm-hmm.
So the idea, they really sort of started with the so-called ban the box movement, where initially there was an effort to remove the checkbox from employment applications, saying that it was acting as a barrier, like right out of the gate before you even got an interview or even had a chance to meet with someone or just to review your qualifications. That checkbox was just categorically eliminating people. And due to the number of people who are arrested statistically, who are people of color or protected class individuals, that was having a discriminatory effect on protected class individuals. And while, having a criminal record doesn't make you in a protected class, it was just statistically the impact or having an impact on that population.
Mm-hmm.
So these second chance laws and fair chance laws sort of evolved out of that ban the box movement and started taking other things into consideration, things like really deferring any questions about criminal history until after the interview phase, limiting the kinds of criminal information that you could consider, and really forcing employers to make the case for whatever questions they were asking, in terms of making sure that there was actually a business related reason for asking the question. Mm-hmm. Is there a nexus to the crime that the person committed or was convicted of and the requirements of the job? So the whole idea around this fair chance or second chance movement is to give people an opportunity who might otherwise be disqualified based on their criminal history.
So as a quick follow-up to that, and I know it was asked later on in the update around asking about convictions and arrests. So are employers allowed to ask in the job application whether or not a candidate has ever been arrested, versus or convicted?
Yeah, I mean, so that depends on the jurisdiction, but generally, I just want to kind of take it back another step to say that the EEOC on a federal level has issued guidance on this point. The EEOC issued guidance in 2012 addressing the use of criminal conviction and arrest information in hiring. And the EEOC came out, I mean, this is not new law, this has been around for some time now. They came out with this guidance to say that you should not be basing hiring on arrest information alone. You really need to do the work to determine whether or not the person was convicted of the crime. Because of our legal system, you're innocent until proven guilty, and lots of people get arrested and they're not guilty.
Right.
So, so the EEOC issued guidance on that, and part of the EEOC's guidance says that you should not be looking at arrest information. A lot of these state and local jurisdictions have taken that guidance and actually codified it and made it the law to say you can't put that on your application. So should you ask about arrest? The better way to really word the question is around criminal conviction history. Mm-hmm. And then the other thing that you need to consider is, are you in a jurisdiction where you are prevented from asking that on the application? And then if you still want to ask about it, should you be asking about it at a later stage in the hiring process? So a lot of these laws say, you should push those questions out until you've determined whether or not the person is otherwise qualified. And keep in mind the public policy around this, and it's particularly relevant for employers today because of the interest in a diverse workforce and the interest that we have as a country of paying attention to issues around race, and second chance and fair chance hiring definitely plays into those kinds of policy decisions. So you need to look at your organization. What are the boundaries that you have as an organization? What are the limitations that you have, or where are there opportunities with certain positions or different types of hiring that you can afford more second chance type policies to be effective.
Yeah, and definitely, key takeaway, and we do stress this enough in our conversations, especially around, compliance. It's different jurisdictions, by state. There's so many different laws and regulations. So just like staying up to date with everything like that, because even with a couple of these questions that we've already addressed, it really does matter, where you are, where you're hiring, and things like that. So definitely staying up to date there. So when it comes to, I want to move into a different area now with candidate consent forms and disclosures, and then authorizing a background check. So the first question I have here is helping our audience understand a little bit more by providing an example. So giving an example of what should be in a standalone FCRA disclosure form.
Okay, so this is a hot topic.
Yeah.
There is still a ton of litigation around this whole issue of disclosure forms, consent forms, whatever you want to call it. In the Fair Credit Reporting Act, they refer to a standalone disclosure and then an authorization to run a background check. Mm-hmm. So there's been a significant amount of litigation on this point, and where we have come in terms of guidance and based on the cases, what the cases are telling us, the Fair Credit Reporting Act says that the disclosure that you're going to run a background check has to be a standalone disclosure, and we know from the case law that you should follow that guidance. Mm-hmm. That even though there's another part of the statute that goes on to say that you can include the authorization with the disclosure, if you have other information in the authorization, it can invalidate your standalone disclosure. So what we have learned is that really the best course of action is to keep your disclosure just simply a FCRA disclosure that we're running a background check. And Sterling does provide sample disclosure forms, and we have stripped out any extraneous language. And I strongly recommend that you go back and look at your own disclosure forms, take a look at them with your counsel, and feel free to reach out if you want to look at Sterling sample forms, but by all means have them reviewed by your own counsel. But the key is to strip out any extraneous language. Don't provide instruction, don't provide a lot of wording about, okay, and this is under this state law or under that state law. Make sure that you keep it clean, reserve any additional information around instructions for getting a copy of your report or instruction around other state law disclosures, or even, some companies used to include a disclaimer or a release of liability on their disclosure forms. Make sure that there's none of that on your disclosure, because what we've learned is it really does have to be a standalone statement, and that will, significantly reduce your chances of being a target of litigation.
So I want to take that. It was a great answer. I want to take that answer and look at it from a specific sector. So Sterling obviously has a huge, volunteers part of our organization. So I want to look into that, area of business. So volunteers, nonprofits. So does FCRA apply to volunteers? And specifically, are there situations where disclosure and authorizations are not required?
Yeah, so the best practice is really to provide volunteers with afford them the same protections that you would an employee in terms of disclosure, authorization, the protection under the Fair Credit Reporting Act. Even if the compensation is not monetary compensation, there could be, and we don't have a lot of guidance on this point, but I think that in general, the best practice is to follow the same guidance and procedures with your volunteer population as you would with employees. Now, some may argue, and there have been some cases that have said, if we have independent contractors, and these are really not employment situations, this is a contract person and we're not hiring them, they're just performing this piece of work pursuant to this contract, and there's no language around any sort of employment related activity, and they're able to carve all of that out, and maybe they're not even using a background screening company to do the background check, then maybe in that case you would not have to provide the FCRA disclosure and authorization. But even if you're falling outside of traditional employment, if you're using a third-party CRA, a background screening company, chances are you're going to fall under some permissible purpose of the Fair Credit Reporting Act, and you should get consent. You should get some sort of disclosure and authorization. And as a best practice, you should get consent for a background check. So the specifics of what that looks like for employment, it's very clear that you need that standalone disclosure and authorization. And for other versions of that, there might be more leeway, but keep in mind that it's a consumer protection statute, and the courts are inclined to protect the consumer, the employee, or the person that's being hired.
We have a couple of just hellos and highs coming across our LinkedIn platform I see right now. So just again, hello to everyone that is joining us live across Facebook, LinkedIn, and YouTube. Two of us are very happy to have you tune in live right now. And just again, a very friendly reminder, if you do have any questions for Angela, please go ahead and put them in the comment section across these three platforms, and I will get them over to her as I see fit throughout the episode. So we didn't actually touch upon this next area in the update, but I do definitely want to pick your brain a little bit here. Can you explain to our audience adverse action notices?
Sure. So this is another area where we tend to see some litigation and class action litigation. And again, with the litigation, keep in mind that the Fair Credit Reporting Act is a statute that sort of lends itself to class litigation because the litigation usually focuses on these very technical requirements of employers that are repeated every time they screen a potential employee. So any prospective employee, any candidate that's coming through the system, if there's a form that has to be presented, and then you multiply that times every time you have a candidate that you're screening, the number of potential offenses can add up very quickly. And there's also statutory damages that are allowed under the act. So between $100 and $1,000 per offense, plus punitive damages and attorney fees, and if there's willful misconduct, it adds up very quickly. So that's why it's such a target for class litigation. And the adverse action process is another process that sort of lends itself to that technical nature of a class case. So the adverse action process is really a two-step process. First, if there's something that's in the background check that you might consider as something that might disqualify the person, you need to put them on notice that there is an issue that came up through the background check. And that's what we refer to as pre-adverse notice. Along with that notice, you have to include a copy of the report. You have to attach, a copy of the actual background check. And you also have to include a summary of rights, which is a document that's published by the federal government. Mm-hmm. So there may be other things that you need to attach based on state and local law. Some of these fair chance or second chance state laws that we talked about, or local laws, may also require that you do additional things in that pre-adverse action notice step. But under the Fair Credit Reporting Act, the main requirements are that you simply, provide the notice, give them a chance to respond, and have the background check attached. It's really like due process to say, right, here's the issue, and it's potentially going to be a problem. Then you have to give the person a chance to respond. So the Fair Credit Reporting Act says you have to give a reasonable amount of time. And again, not spelled out, not clear, but we do have some guidance to say that at least 5 business days would be a reasonable amount of time.
Yeah.
Some state and local jurisdictions require more time. So that's, another reason that you need to be paying attention to all these state and local laws.
Exactly.
And then once you've given a chance to respond, if the person doesn't file a dispute or doesn't respond, then you would, if you decide that you're not going to hire the person, you need to send them what's called the final adverse action notice. And that is, just a statement that they're not eligible, and give them a little bit of information about how to get a copy of the report and what to do next. So those are the basic requirements. And as I said, they're a little bit complicated today because there may be other state and local requirements that you want to factor in. And there's also, you may be wanting to do some kind of an individualized assessment, which is another EEO requirement under the EEOC between those two notices. So I hope I didn't completely confuse everyone with that, but.
No, but a great explanation and an important question for both employers and for candidates going through, a background screen. So really understanding what, does happen in regards to adverse action. And then also for employers, like we've been saying all episodes, staying up to date and making sure that you do understand state by state what's going on and what can and cannot happen. So very important question for there. So I'm happy we were able to go over it today and cover off on that for sure.
Yeah, just one thing about adverse action. I think that, again, if you think about it in terms of it's really due process for the applicant, for the candidate, to give them an opportunity to say, hey, this isn't right, or this isn't, there's an error on this report, or this is right, but it's, I want to, there's something in here that's inaccurate or incomplete. That's the purpose of adverse action. And I think that companies need to respect that's part of the process. Sometimes companies think, well, I'm going to give the person a call and let them know that there's a problem with the background check before I send out the notice. What they're actually doing is then they are invalidating the notice by maybe tipping off to say, hey, you're not going to be hired, or you're not eligible for this job. And under the law, you can't make that decision until you've given them a chance to review and already sent that notice. So I think sometimes in their effort to be communicating with their applicants, it's, sometimes employers make the mistake of doing some other communication or contact that doesn't include all of the requirements of the pre-adverse action notice. So that's where you see some litigation where somebody sends information to the applicant that really is out of the process.
Mm-hmm.
So try to stick to the process. Make sure that you've got those notices in writing that you can send out to document that you did it on time, that you did it in the right time frame. And it's always important to have all of that documented so that you can fall back on that.
That's great. So there was a question from last week that we did want to follow up with during our recap today, and it will close out this section of the episode right now. So last question here, is a credit score considered more important than other parts of a background check?
So interesting question, because, the majority of clients don't really need a credit check. And, I think that the PBSA has done surveys on this point, and I think only like 20% of employers run employment credit, and that's not even on their whole population. Keep in mind that when you run an employment credit report, it's not like a normal credit report. It's a pre-employment credit, and it contains only limited information, and it does not include a credit score. So I think that what you need to keep in mind is it's not something that everyone needs. It's not necessarily important for most employers, but when you do run credit, you should be able to tie it to the requirements of the position.
Mm-hmm.
And in fact, a number of states have made that the law, that before you can run a pre-employment credit report, you have to disclose to the candidate that you're running credit, and you have to identify the reason that you're running credit. In other words, you have to be able to identify that there's a legally permissible reason to run credit that's related to the job.
Right.
And so that is a requirement in a number of states. Also, in some jurisdictions, there's limitations on information about about credit being in the disclosure unless you're running credit. So it is a very specialized type of background check, and it should really be used for the specific purpose when there is something in the position like a financial fiduciary responsibility, handling of cash, anything dealing with the finances of the organization, where the person would have responsibility, where credit would be relevant.
Mm-hmm. All right. So that's a great explanation there. Great answer. Thank you. So we stressed a lot over the past 32 minutes around staying up to date, making sure your organization remains compliant, because so many things are changing on, as quick as a weekly basis. Things are changing from state to state and everything. There's a lot going on. So I do want to wrap up the show today with, helping our audience understand how they can stay up to date and remain compliant. So what is the best way to stay on top of changing state laws that may impact the specific forms that are sent for FCRA compliance?
Yeah, so obviously, stay in touch with Sterling.
Yes.
We do put out a lot of content on compliance. In fact, I have a blog post that's live on the website now about second chance hiring that really dives into some of the stuff that we talked about earlier in the show today about second chance, fair chance hiring, what it is and why it's important to know, and some of the laws related to that. Make sure that you are, following us on social, webinars, obviously, talking to your screening provider. If it's not Sterling, then obviously, don't hesitate to reach out to your screening provider, because it's our job to stay up to date on these laws and address them in our platform and the way we deliver services. So I would definitely recommend that you follow us. There's also, I don't know if we can publish like the .info how to follow us on some of the different update tools that we provide through Sterling. Definitely talk to your account manager if you're a Sterling client and you want more information about getting on our lists so that you're notified about those things. But yeah, I have a social media blog post coming out in June talking about social media compliance and all of the issues related to running a social media check, which I think there's a lot of interest in that as well. So yeah, follow us on social and we'll try to keep you up to date.
Absolutely. There are so many ways that you can stay up to date and remain compliant. Sterling is here to help in those regards for sure. So definitely follow everything that Angela just said. Quick, final call for questions across Facebook, LinkedIn, and YouTube. If you have any final questions, go ahead and put them in the comment section and press enter and I'll get them over. But in the meantime, would love to grab just some final thoughts from you, Angela, in regards to today's episode, the FCRA update last week, anything else compliance related, final thoughts?
Gosh, I think we covered a lot. I feel like I always end up talking so much.
But it's great. Now, honestly, it's the best for our audience. They need to learn this stuff.
Well, at least today you didn't hear the honking of the horns and the sirens of New York City. I'm in a more tranquil environment today, but yeah, I think it's still very much an active environment as far as compliance. It's rapidly changing. Don't be intimidated. It's manageable. You can manage it. Just find good information sources and partners that you can trust and develop that internal knowledge. I think is really important to build within your own organizations. But we're here for you if you need us.
Absolutely. And as Angela said, we covered off on a lot of items this episode, a lot of great items, great knowledge distributed out to our audience. So be sure, if you aren't watching live, you're catching this on demand, watch this entire thing. You can also get the entire FCRA update that we had last week on demand. That will be in the comment section across Facebook, LinkedIn, and YouTube right after we wrap up. You'll be able to find that link so you can download that recording and listen to that as well. Also, please visit our website, www.sterlingcheck.com. We have a ton of resources in regards to compliance. We also have a compliance section directly related to compliance where you get all updates. There's documents on there. That is at sterlingcheck.com as well. So you can find all of that great information. We are here to help for you to stay up to date and to remain compliant. But at this time, we don't have any further questions. So that is our episode. Again, week after week, just delivering great episodes. And this was just another one that came in right now. Oh, actually, we think we do have a question. So hold on one second. Let me read. It's a long one. So let me read it real quick. Last minute question here. Okay. This is okay. So I'm going to go ahead and ask this to you. So when potential employees or volunteers read the standalone disclosure that explains their background check will be run, there is always a question about the language credit reporting agency. What is the best way to explain to potential volunteers or employees that we are not running their financial credit, but only a background check?
Yeah, the terminology can be confusing. And I think that, one thing you could do potentially is customize your form to explain consumer reporting agency. The actual legal term is consumer reporting agency, but in California, it could be referred to in different places. It could be referred to with different terminology. Mm-hmm. So, you can customize the language to have like a parenthetical to say background screening company or something like that to explain. You can also provide outside of the form, you can do maybe some preparation for your candidates to explain to them, this is what this form is, this is what it means, and we're not running your credit. What you can do in terms of candidate education before they jump in or see that language that can be intimidating. maybe there's something you can do to mitigate it by helping them along in that process with some guidance or just information about it. Because I think it can be intimidating for candidates to see all of that legalese and very technical language that may be required under statute, but can be confusing.
Absolutely. Well, thank you for answering that question, and thank you for the question submission for the show today. So I think that actually is it now for unless line comes in real quick. But yeah, so this was, absolutely an incredible episode. I learned so much. I know our audience learned so much from you, Angela, as they always do with all of the content that you release for Sterling in regards to background screening and compliance. So thank you so much for joining me today. Thank you to our audience that tuned in live and are then watching this on demand. Thank you, as always, for tuning in to Sterling Live. We do come at you each week at around 1 p.m. Eastern, usually on Tuesdays, but sometimes I like to spice it up and throw a new day of the week at you. But again, we will catch you next time. But Angela, thank you so much for joining us today.
Thanks, Caitlin. See you next time.